The future of IP directors in the age of artificial intelligence. Greetings and welcome back to Invent Anything. Coming up, you'll start to learn why AI is both a lifeline and a landmine for IP directors, especially when the big players move slow and the startups move fast. We'll explore why rolling your own AI strategy as an IP director is smart, and it might be the only way to stay relevant, and might be the only way to control your IP in the future. This is John Cronin. Welcome back to Invent Anything.
Inventions keep the world spinning. From fire in the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
Today we're going to cover 6 topics. In the first topic, we're going to talk about the general issues of IP directors and artificial intelligence. In topic number 2, we're going to talk about why IP directors have trouble today, what's going on, and the difference between large IP AI companies, meaning large companies that do IP that have AI, and small companies that try to use AI for their IP. Then we'll go to topic number 3 to give a specific example. And here we'll choose how to reduce the cost and increase the quality of the number of patent filings, one of the simplest things that IP directors face. And we'll use that topic as a way to discover just the problems for that when the choice is whether to use AI or not. In topic number 4, we'll talk about the world of the IP director if they don't roll their own, meaning if they don't decide to bring in AI and also create their own AI themselves. In topic number 5, we're going to talk about the world of the IP directors who decide to, quote, roll their own IP using AI. And that's the world where they're really using AI to help them do their job, but also making their own AI to do it. And then finally, topic number 6, the future here is really to talk about a new player that comes on the scene, which is the AI prompt engineer that joins the staff. And that person might help the IP director, and the IP director may become the chief IP automation officer at the end of the day, the CIAO. And I chose these topics to just give you an indication of this world. I decided to do this podcast because I started to talk to IP directors and I saw basically a duality. There's the IP directors that have embraced AI and start writing AI themselves. And I've seen other IP directors who just can't do it. And they're blocked for all sorts of ways. And they're feeling kind of bad that maybe this is going to affect the long-term health of their company and their career. Now, for the audience, I've sort of thought about this and think that IP directors are really the key audience, big and small companies. But also for those that may not be familiar with IP directors today or tomorrow in the future, it might be very interesting to understand this world that they're in, because you may be somewhere in the corporation not understanding this. A third audience could be those who think about how AI affects IP in general, because affecting the IP directors is a key person in the organization for IP. A fourth area for audience could be sort of understanding this 2 classes of the issues. That is, IP directors who want to use AI and do, and those IP directors that want to use AI or maybe even refuse to, but either way they can't or they won't. Another audience could be sort of the eco structure around the IP directors, the patent attorneys, the patent agents, the docket clerks, the software providers, the R&D manager, the CEO, etc. And finally, and we'll spend time at the end on topic number 6, but I think the audience for what I call AI prompt engineers will be very important. I know this firsthand because in my firm, IP Capital, my son Seth, who's now the CTO, has embraced this IP automation using AI, and that he's an expert. He's an expert at IP. He's an expert at AI now, and now he's an expert at IP automation of IP tools and techniques as a content expert in IP. So Coming up, what you'll do is listen on to two different topics: why IP directors are struggling to get real value from AI, where they're caught between the clunky legacy tools that they use for IP, and where startups are trying to supply tools to them, and they might not trust the startups for IP tools. And we'll look into where AI can actually solve pain points across the IP, workflow, and how the next wave of solutions will need to be custom fit, not cookie cutter. And I hope to make that clear. Again, stay tuned. This is John Cronin, Invent Anything, and welcome back. So, topic number one, IP directors and AI issues. If you're an IP director, you're going to agree with most of this, I would assume, but also if you're not an IP director, you'll sort of get at least an understanding what IP directors do in companies. When I was at IBM as an inventor and then asked to create an IP program, I kind of became the IP director for IBM, which turned out to be the IBM Patent Factory, where we generated a lot of patents. We went from about 1,000 patents a year to 3,500 patents a year. That took about 3 or 4 years to do. And then the company started monetizing, and we went from about 20 million a year to 2 billion a year in licensing. So I had a lot of insight as a person who did a lot of the jobs of an IP director. As I started building IP Capital, today we've been in business 27 years. We've worked with about 2,000 companies and about 15% of the Fortune 500. So I've had the pleasure of working with a lot of IP directors. So I'm just going to kind of review sort of the things that IP directors do and maybe some of the AI issues. So the first is that one of the things, of course, IP directors do is manage patents, trade secrets, and trademarks. And here, what they're trying to do is they're constantly trying to tune their processes to do the best they can. AI could help them identify which assets are undervalued, overexposed, or ripe for licensing or monetization. But managing patents and trade secrets is a big part of what they do. A second thing that IP directors do is they try to determine ownership of the IP, who is the inventor, etc. Who owns the trade secret? Who knows it? This is a real challenge with AI because even the patent offices are wrestling with, can an AI program be an inventor? So they have to watch their inventors, making sure they're not using ChatGPT to write all their inventions up. So ChatGPT can do a substantive amount of work in the other large language models. The third thing is competitive intelligence. IP directors do this all the time. They're analyzing competitors and looking at IP landscapes and the competitive positions and the white space. And it takes time. And there's a lot of work to do here. AI tools can certainly help monitor the global filings, the research activities, and they can surface patterns and show things that might otherwise have gone unnoticed. So it's a challenge if an IP director does not use AI for competitive intelligence, because if he has competitors that do, he might be behind. A fourth area that IP directors face is the growing workload. They're trying to have their job be done as fast as they can, as cheap as they can, with high quality, but they're always asked to be leaner. So that it's tough for them to be efficient in an environment where there's not an infinite budget for help. So automation of repeatable tasks would certainly help out in terms of docketing, prior art, portfolio audits, and that might lead them to have more time to do more strategic thinking. Another thing that IP directors do is they really are there to help inventors and help motivate them, help them, thrive. AI can certainly help inventors as an intern associated with developing their inventions. AI can help them, the inventors, see the value of their ideas. AI can search the web and interact with inventors, doing a lot of the things that the IP director used to try to do to motivate. So there's obviously a place where AI could help the IP director. One of the key places IP directors play is that they have portfolio alignment, discussions and processes and workflows so they can align to the business strategy. They have various ways they look at this information. So AI could certainly help by developing dashboards for visualization or have maps, etc., to support the growth plans of the company. And when it comes to building strategy, IP directors, that's a big focus of theirs. So AI scenarios could be used to help show the IP director various pathways. One of the areas the IP director works is on risk management. And so AI could proactively surface conflicts and claims, etc. Another place the IP director works is in risk management, so that they're not just reacting to problems, they're trying to manage in advance. So AI can proactively look at all sorts of issues, from competitive intelligence, compliance red flags, all these things that can become costly. Another thing an IP director does is negotiate licenses and and construct research agreements, etc. So certainly AI can assist with contract analysis, flagging important clauses in the analysis of the contract, even helping substantively to write pieces of the contract. And then finally, even training is an important thing that the IP director tries to do. AI-powered platforms could certainly be taught and give content to do the training. So we could see all the things that an IP director does. I've named 10 of them, and each one you could see how AI plays a role. Let's go into topic number two to consider why IP directors have trouble. And we're going to use an example of sort of IP directors of large companies, say 500 people and up, versus small companies that can use IP. I mean, if you're an IP director of a company that has 100 people, you probably have a lot more flexibility in terms of what kind of software tools you can bring in. And if you work for a large company, we have to work with the IT directors. So let's take the case of an AI industry for IP which we're trying to help support the tools that are centric uh, to their process. So today, large companies can buy platform IP tools like Clarivate, which means the docketing system where you can enter in your dockets, when to file patents and pay, various maintenance fees. And basically, the IP directors and the IP managers are working with that tool every day. It's a pretty, you know, sophisticated tool. It takes months and months to bring in-house, and it really becomes sort of the backbone of the workflow. So in topic number two, we want to talk about IP directors and why they have trouble today, and giving an example. And we're going to talk about sort of IP where AI is used in large companies and IP where AI is used to help small companies. The first thing we have to understand is these large companies tend to buy very expensive, sophisticated software tools to manage IP. Tools like Clarivate, for instance, whereby it's a big installation, takes months, a lot of training. It might manage the docket system. It might manage, you know, it receiving inventions from inventors. It would manage reports, tell you when to pay fees, etc. And I want you to imagine my large company has that installed. They may even have competitive tools like PatStap or PatSeer, where they can do online competitive intelligence of the patent literature. Now, let's jump over to a small company for a minute. They would never be installing systems this large. Most of the time, they'll be tracking things with Excel worksheets and things like that. So if we look at these two different scenarios, what we also recognize is large companies have a lot of restrictions on the kind of software that they can bring in. Whereas the small companies, they can pretty much try whatever they want. When ChatGPT first came out, most large companies said you're not allowed to use it on your work in the enterprise systems because they were afraid of teaching prior art to the AI. Small companies didn't bother with this. So what happens is these tools that are embedded, most of them are there to manage workflows so that it's making things mechanically better. However, when you start looking at some things that a startup can do, uh, startups or early stage companies, companies below, say, a couple hundred people even, they can play with AI and do all sorts of things. And this is kind of where I learned the problem of IP directors, because the IP directors of large companies said they couldn't do that. They couldn't bring these tools in. Another thing to note is that there's a lot of AI being developed for IP, uh, and there's dozens and dozens of IP workflows. Even in IP Capital, we have 50 different services. We have freedom to operate, evidence of use, valuation, IP extraction, invention on demand, all these different tools in IP. Each one can be separately automated with AI. But recent studies that we've done shows that almost all the startup companies that are creating AI tools to sell to big and small companies are really trying to improve writing up patents. And the feedback we get from our large clients and our small clients is they're not very good at all. So if we take a look at the industry, large companies um, don't have the ability to even bring in those new tools that are being developed by small companies that are funded to develop a better AI for disclosure writing or patent writing because they can't bring it into their enterprise. The IP industry is also such that these very large companies get held up because they can't integrate AI solutions into their large platform like Clarivate. They're really waiting for the Clarivates of the world to come up with these AI tools. The IP industry also, as they support large companies, uh, these large companies like Clarivate and others that might supply innovative things to the large companies, they're they're really focused mostly on keeping their own software running, and they're not adding a lot of IP features with AI. And they may start buying small companies that have AI so that they could integrate it into their large system. But the problem is that's a problem. So if I'm a large IP software company and I'm not keeping up by developing AI tools, then I go out and buy some early stage company and try to integrate it into their workflow platform, and it becomes really difficult. Another issue is that if you take a look at the IP industry, out where the software companies are supporting large companies have their entire legacy systems wrapped around these large AI tools like Clarivate, IP tools like Clarivate. And so if the large software company like a Clarivate creates the the upgrades, then they have to go into the large company and integrate it. So it's a real problem with these large software companies for IP making changes to large companies that use this IP tool. Um, One of the things about this whole mess is that IP directors, in order to even be able to communicate with what software they need to know the language. They need to know what a large language model is, what a vector database is, what a corpus is, what an action prompt is, etc. And if they don't play with it, they won't know what questions to ask. So when they're trying to size various options of new software to bring in, they're stuck. Um, the other thing is that IP directors have, in essence, the most important domain knowledge that should be used by the companies developing the AI for IP tools. So if we have somebody that's developing an IP tool for disclosure writing or patent writing, if they don't have 15 to 20 years as an IP director in a large company, that AI tool they're writing is not going to be very valuable. Because we found even in IP Capital, when we're developing our own AI tools, that domain knowledge is where you get the quality from. And the next and sort of final thing is that these large companies that have IP directors probably haven't even played with enough prompts to improve their job using AI to know what a prompt engineer should even be doing in a large company. So to kind of summarize, you got very large companies that buy large software platforms for their IP. They can't go out and buy seats at small AI companies that have created IP tools because of all the issues of security and all the rest. So they sit around waiting for the large software companies to develop AI. And those companies find it difficult to develop it because they're large. And by the way, if a large IP software company bought a small AI company that developed IP tools and they integrated and installed it, by the time they installed it, uh, the next AI would be right behind it with all the changes and benefits of the new AI for an IP tool. So they're really stuck in this vicious circle of time. So it's a real problem. How IP directors use AI becomes problematic. Well, that leads to the next topic. So coming up, what we'll hear is some real reasons why large company IP directors hesitate to adopt these AI tools, even when they could cut their costs and boost quality. And then we'll uncover what happens if they don't build their own AI and how, if they don't, falling behind is such that they start to lose their position. And it may actually turn out that our IP directors in the future become less employable in their own industry because they don't have this new skill. So stay tuned. So let's talk about topic number 3. AI that's going to be used by IP directors in some specific uses. So if I have an IP director of a large company, what they would like to do is they'd like to reduce cost and increase quality so they can increase the number of patent filings. Can AI help? Absolutely. Can they use AI to do it? Today, most likely not. IP directors of large companies, um, they each have different types of technology they deal with. So some IP directors are in companies that deal with chemical formulations. Some IP directors may work in a company that develops, software as a service or new business models. It turns out that the IP tools that are created for the IP director would be drastically different for a chemical company versus a sort of software as a service company. So it turns out that the IP director is really going to have to roll their own AI to actually have an AI that's going to work for them because a generic AI is likely not going to work very well. Another thing is that IP directors of large companies, have to sort of worry about getting their disclosures that are written, maybe helped with AI to get through the review process. And some IP directors deal with disclosure forms where inventors fill them out, but there's not a lot of content in the disclosure form. Other companies demand lots of content and prior art studies. So if I'm trying to develop an AI to take a disclosure and turn it into, a first pass specification using AI, if the input is very different between two companies, the AI is going to work drastically different. So IP directors are faced with that. Another thing IP directors of large companies are concerned with is inventorship. There are very strict policies to ensure that they're adopting the guidelines of the patent office that AI can't be the inventor. The human being has to be. And so they need to be able to kind of monitor the use of the inventors using the AI, or they need the AI built so AI doesn't do the complete job. Once again, all these new AI tools have a lot of variation. So an IP director of one company may have a different clip level with inventorship versus an IP director of another company. Another thing is that IP directors of large companies that file patents might use internal counsel, patent counsel, to file the inventions. And if they start to request AI being used by internal counsel may feel their job is threatened because they might have 10 patent counsel on staff. Maybe through the use of AI to get it adopted, you only need 7. Some IP directors actually hire outside counsel. Outside counsel needs to charge the rates they do because they have overhead. So if they try to force outside counsel to use AI to lower the outside counsel's cost, they'll be resistant. So just in the counsel part of IP directors, we can see the problem. Another thing is that IP directors of large companies might worry about that AI tools will make inventors lazy. A lot of times, IP directors are trying to get the inventors to go back to the laboratory to collect more data or to develop the flowchart better, etc. And if the inventor can simply go and open up a large language model and have it do the job, believe it or not, um, you become lazy. Now, it's one thing for us to say that when we had calculators, that would take away our ability to calculate, which is certainly true. You probably can't find a person that you know to be able to do long division by hand. They don't even remember how to do it. How about your GPS? You use it to go pretty much everywhere. How many people will go to a new place using a map without an automation? So certainly these tools give us more time for other things, but make us lazy. Would the skill of the inventor be of a concern over time? I think so. Another thing IP directors of large companies do is they have to make sure that the inventor contribution of enablement is supports the claims. So if you have a claim of a patent, maybe you have multiple claims, the inventor came up with 3 or 4 of them, but the AI came up with the other 7. There's a real problem there that you've now used AI to enable a claim. Controlling that is very difficult by letting AI into a corporation. One of the other things that IP directors do is they deal with R&D. And if they use AI agents to enhance their patent writing, it might take a long time to deal with the R&D managers to how to figure out how to insert AI into the R&D process to then search AI into the disclosure process. And I'm just using the patent process as just one of the areas of the IP director. Notice I talked earlier that these IP directors manage 50, 60, 70 processes, free to operate, evidence of use, prior art, valuation, you name it. So I'm just talking about patent drafting, and we can see the problems just with patent drafting. Also note that AI tools today, 90% of them are written around patent drafting, not around the other 59 to 60 other things that IP directors do. So boy, there's a lot of work to be done. Another thing about IP directors of large companies is they have to deal with IT in their company to ensure security so that they don't lose trade secrets. Now the IT director needs to know about the AI input and output. The IT director now has to learn about this as well as the IP director. And finally, and I could go on about this, IP directors of large companies don't realize that the journey of an AI patent writer tool isn't just a one-time event. I've seen this in my firm. 7 years ago, we started to try to enhance using computers the workflow of drafting inventions. We write thousands of them and have a pretty high success rate in getting them through the patent office, about 85%. We're on version 35, I think, 34 of the turnaround times of the internal tools we use to do this one process. So just when the IP director thought everything was done, version 2 is on its way. This is the problem with AI. You don't just install it once and get the benefit for a year. You install it once and by tomorrow, there's something else. So this is a real problem for IP directors. So let's switch over to topic number 4. Let's suppose that our IP director says, this is all confusing. It's disruptive. It's costly. I'm trying to do my job. So I'm not going to get involved in this. I'm just not going to get involved in all the things that I'm talking about here. So what will happen? Some simple predictions. When compare that IP director who will not roll their own to an IP director that will roll their own, meaning they'll start to develop their own AI for their own workflows. Our IP director who decides not to embrace this is very likely to be cost ineffective. So their cost effectiveness will wane over time in comparison to the companies that do. Their quality is going to get worse because now using AI, you can use AI to read millions of documents to figure out maybe enablement claim space if I'm just using disclosures or free to operate. How many documents can I look at? how could you compete on the quality side if you don't embrace AI? One of the big issues with IP directors with the patent office is first to file. So speed is everything. Well, AI roll your own IP director is going to get there faster. So the IP director that doesn't roll their own is going to start losing rights for the company. Another thing the IP director will definitely do if they don't roll their own is they'll impact R&D's influence on the leadership of their inventor community, because their inventor community, even though I said it might make them lazy, this is the balance that we have to work on. The internship of an AI with an inventor provides huge, huge leadership. So the company may lose its technology prowess because their inventors are not using AI. Because remember, if the IP director decides that you can't use AI in the corporation, the competitor's corporation could, and you could lose the battle of competitiveness. The other thing that would happen with these not roll your own IP directors is they'll get behind the competitors, because if they can't do competitive analysis using AI, they're going to fall behind versus the ones that do. They're going to find that there's more risk, meaning that if they're not rolling their own AI to do freedom to operate or prior art to make IP decisions, and the competitors are, they're going to be doing it the old way. Things are going to be more complex. So there's going to be more risk for the IP directors that don't roll their own. The IP directors that don't roll their own are going to find it's harder to hire bright people, young, bright people that are coming into the IP industry. They want leading edge tools. They probably went to the university where they started learning some of these tools. Then they go in a corporation and they can't use them. So what happens is their IP director falls further behind, and the IP director is not even understanding the language to understand what large language models and corpuses and all the rest are doing, what generative AI is, etc. And eventually these IP directors get demotivated, watching their industry pass them by. And that's actually one of the reasons why I did this podcast. I find that some of my friends that are IP directors are now stuck. They can't bring in the AI tools. They're seeing the world go by, and they believe that they're not as employable as they used to be. That's a pretty big problem. So what's next? Well, coming up, we're going to hear what happens when the IP directors stop waiting and start rolling their own, becoming, you know, the AI director, if you will. And we'll explore how these leads to what calls an AI prompt engineer, where this automation of the prompt to do the work becomes especially valuable. So stay tuned. So now let's talk about the world of IP directors who roll their own. I made up this phrase trying to show the difference between IP directors that don't embrace AI in their many different workflows and the IP directors that do. And we've worked with some that do, and we started recognizing some of these IP directors are challenging us because we build a lot of AI tools to kind of end up in these mini competitions between some AI tools that they've built internally or AI tools that they brought in versus what we can do. Now, it's difficult for these IP directors to try to roll their own because most of their time is not spent writing AI tools. So it's very likely they're not going to be able to compete. On the other hand, if they bring in IP tools from companies that raise some financing to write an AI to do a particular workflow, the people in that job probably don't have decades of experience in doing that job, but also very likely they might come from one domain, like I said, chemical formulations. And the solutions they provide are not optimal for other technology directions. So in my firm, because we've done 2,000 companies and so many technologies that we can kind of look at it from a different point of view, but it's not to say that an IP director that rolls her own is bad. We're in this topic, we're saying we believe this is the way it needs to happen, and they're going to have to do this to the point of getting better and better at it. So one of the things that happens if you roll your own is really just the opposite of what I talked about. I talked about that the IP director who don't roll their own, Their cost is going to be going down. I mean, the cost is going to be worse. The quality is going to be worse. They'll lose against competitors. They'll lose influence in R&D. They won't be able to do competitive intelligence as well. The risk is going to go up. They're going to find it harder to hire. They're going to get further behind. They're going to get demotivated, and these IP directors may become less employable. I hope that doesn't happen. But obviously, if I roll my own, I have the ability to make sure none of that happens. But there's some other stuff that happens. The first is that these IP directors that roll their own with AI will help push and help AI for IP directors influence all the workflows. Because when you're doing AI for an IP workflow, it's going to affect accounting, it's going to affect sales, it's going to affect marketing. So if IP directors became the leader of bringing in AI in the corporation, which I think it should, because they're the primary place that they can guard this issue about losing rights, the IP director becomes the only place a large company might allow AI to come in first. Could wall it off, put it in a sandbox area, etc. But what happens is when the IP directors start adding AI and rolling their own, they immediately see that they need to connect to all the other systems and almost like a virus, kind of get these other systems to want to get AI in them as well. Another thing is these IP directors that roll their own can be freed to use AI for brainstorming and literally unleash invention in the corporation. An AI director that rolls their own can take the company's corpus, that is the data set of the company, and use that to inform the AI for IP strategy. So now what happens is IP strategy happens at lightning speed, at a claim level, versus every 6 months to try to pull that together. An IP director that rolls their own will start to be the agents of decision making. In other words, I can only get the corpus with my IP director prompts running so that any place in the corporation could have an IP director on their desktop, no longer having to wait for a month to get a meeting with them. These IP directors that roll their own will also be able to create sort of an IP director with domain knowledge to drive that corpus that I mentioned, so that the corpus helps inform the AI. The IP director puts the corpus and the AI together. So what happens is decisions can be made on information in weeks that take weeks that would take moments. If the IP director can roll their own for AI, they're going to free up time. And that means they're going to have more time for creative efforts. By the way, this is the sort of overall goal, right, of using AI in your job. IP directors should start working less hours after they've gone through this whole exercise of integrating AI in, rolling their own. And that means when they work less hours, then the IP managers will use AI and their work will go down so they can be more creative. And AI becomes the intern, and AI helps with IP communication. So as they work less hours, they can start using AI to do more things to get everybody to work less hours so that they can all have more time to be creative. IP directors that roll around with AI might even find that they're uncovering new IP assets that were never known. This is kind of weird, but we all understand patents and trade secrets and trade names and copyrights. But there's lots of new IP assets out there. Things like trade enablements is an example. How you particularly enable a particular area of technology inside of a patent. Many times have taken years for internal IP counsel to find the way to get claims through the patent office that maintain breadth and novelty, etc. These kind of secrets, if you will, can become manifest, and IP directors who roll their own with AI can start to develop even new internal assets. Said a different way, if you have a set of prompts that you develop inside your company to essentially extract from some content some really strong claims that where the specification is really well enabled with some options, and it's your set of prompts that does that, those set of prompts become your IP asset. So what happens is it's not just the corpus, it's not just the workflow, it's not just the IP director, it's how that IP director working with the corpus, working on that workflow helps develop a very workable um, set of prompts, regenerative or not, and that becomes a core asset. And finally, these IP directors who roll their own will actually at the end create more value for their company across the board. So if you're listening to this, you might think it's obvious. You know what? I'm an IP director and I'm going to move to roll my own. Or look, I've started to roll my own and I've got some real problems as an IP director. If you're an IP director and you haven't rolled your own, this might get you to try to justify that you start hiring a few people to explore this in your own sandbox, which is our recommendation. Topic number 6 is the natural consequence of an IP director rolling their own, which is to actually employ a prompt engineer. And this person might, at the end of the day, take over the IP director's job. It's called the Chief IP Automation Officer. That doesn't exist today. You know, the Chief IP Automation Officer might sound like a funny name. It doesn't exist, but you know, the Chief Information Officer didn't exist a long time ago until people started using more and more computers. So basically, the Chief Something Officer, if you watch, there are more different types of Chief Something Officers because of the change in technologies that companies have started to use. So if we have an IP director that somehow themselves or working with others are doing IP related prompts, now what happens is I develop a new skill set. So this allows in this world where the IP prompt engineer happens is that unleashes an IP tool, an AI toolbox inside the company. That prompt engineer will be working maybe 2 hours on helping an inventor, to clean up their invention disclosure. 2 hours later, that prompt engineer is writing prompts to extract from a database of 100 patents some key competitive insight. 2 hours later, that IP prompt engineer is going to be looking at a particular contract, trying to extract, language that may be sort of vague to clean that up. And the last 2 hours, maybe that IP prompt engineer is trying to find a way to automate the connection of the output of the review board into the input of the docketing system, writing an AI for that. And then there's tomorrow. So this IP prompt engineer becomes a very unique person and skill. I believe there's going to need to be a sandbox around that person where it's a secure environment. I believe that chances are this IP director that brings in a prompt engineer is really going to go on to sort of a tech scouting mission to find these people. By the way, not only is this tech scouting going to be to find the people, but the IP director themselves with the prompt engineer might be scouting for new AI technology. Just recently, using some chat engine that developed a new graphics program where if you asked it to draw something, it wouldn't draw it with words spelled correctly. It didn't really get it, et cetera, et cetera. Today, the new ones are about 100 times better and faster and more succinct. So what happens if you have a graphics tool that can now render, an invention in terms of figures instantly? Look at how much time that's going to save. If you didn't know that tool existed, you wouldn't be able to use it. So our IP automation engineer is going to go find these tools, like a tech scouting. By the way, when you find the tool, you don't need to hire the person. And then it's all about widgets. That IP prompt engineer is writing a widget for this and a widget for that, right? Some new regulation checking that's done. In other words, the patent office may come down with some new case law or rule or regulation, which creates an event. So our IP automation engineer creates AI to deal with that, to make sure that it's checked, balanced. And what happens is that the IP automation engineer becomes number one for the IP directors. I'm sort of thinking about a Star Trek metaphor here. We have the captain and number one. The IP director works with the IP prompt engineer, joined at the hip every day. The IP director might want to learn the tools of prompt engineering, but my advice is not to do that. And then what happens is the the prompt engineer becomes the number one of the IP director. And this is sort of a Star Trek episode when you have the captain. He always has number one, right? And so the number one of the Enterprise, William Riker is sort of number one, for Jean-Luc Picard, the captain. So the IP prompt engineer becomes number one of the IP director, the joint at the hip. The IP prompt engineer gets better and better at writing prompts, gaining more information about the domain. And the IP director spends more time managing the prompt engineer. In this future, there's always the sort of problem that the IP director might want to start doing prompt engineering themselves. I would say don't. I would say sort of stay away from that. I would say that what you need to do is to let that IP prompt engineer become the master of that, where you become the master of how to use that prompt engineer. And then, of course, there's the away missions, right? Every once in a while, the IP director might want to go on an away mission because there's something to explore. There's some fire drills and there's new reporting. So just like years ago, you'd go to a thought leadership conference and listen to someone tell you about a new way to handle some workflow, or you'd give a paper yourself because you figured it out. What's going to happen is these AI tools might become instantiated in ways that we can trade them and use them. And so what happens is these become sort of AI away missions, if you will, to explore new vistas of how AI can be used in the IP director slot. Well, there's a lot there. So let's wrap up. In the beginning, in topic number one, I talked about how IP directors and have AI issues. I talked about how their role is to try to boost innovation, cut cost, improve quality, help make company-wide decisions. And we talked about the problem of how bringing AI in-house is problematic, where it might have to involve new roles and new risks, and how these IP directors, all the things that they do, AI can certainly help, but they tend not to bring it in. In topic number two, we said, let's look at the IP director of large companies versus the IP directors of small companies, but also let's look at how IP tools are actually being developed by small startup companies, where the large companies that the IP directors use, the Clarivates of the world, etc., PatSnaps and all that sort of stuff, how those large tools with large companies are installed with legacy systems, and how these small IP companies that are developing tools and techniques can't be brought on top of that because they're not connected and they could actually impact each other negatively. In topic number three, we talked about specific examples, like just filing patents. We sort of unpacked why large companies' IP directors struggle with adopting AI, facing everything from the tools are too generic, they don't work on composition of matter or software as a service, they're tuned for one thing and not the other, how there's all sorts of integration hurdles. We talked about, how you can take a look at how you'd have to educate your ecosystem, the R&D, the inventors, etc. So IP directors of large companies have a real problem with bringing in AI tools on top of their legacy system. But in topic number four, we started talking about what happens to an IP director that doesn't roll their own. Well, we said that we believe they're going to lose ground. They're going to increase cost over their competitors. They'll probably lose the battle for speed at the patent office. They'll probably lower quality. They may lag behind. As a matter of fact, they themselves might not even understand the language anymore. They may get too far behind. And then all of a sudden, they don't even understand what's going on, and they become even less employable in their own fields. AI is a tool that has that possibility of replacing lots of jobs. And IP directors are no different than most of the other jobs that AI could take over. So it's important to understand this. On the other hand, we did talk about what would happen if an IP director rolled their own, meaning they bring in their large tool that they use. They recognize that these small startup companies that generate IP tools don't have anywhere near the ability to be secure, don't have anywhere near the ability to be good enough for them. And they decide they're going to invest in rolling their own. They're going to get an IP prompt engineer, and they're going to introduce that function into their company and start developing AI widgets everywhere. So in topic number five, we said certainly the IP director that rolls their own is going to be able to hopefully solve all those problems we mentioned of those IP directors that don't roll their own. Their costs will be better, their quality should be better, more timely, the competitive analysis is better, et cetera, et cetera, et cetera. They lower risk. So that's all good, right? If that's good, then it leads to topic number 6, which is this AI prompt engineer, which eventually becomes the chief automation IP officer, the chief prompt engineer, if you will. And when introducing this concept, we said this is a key new role where that person with the IP director starts solving all sorts of problems. How to make the AI write a better disclosure, how to make the AI do better competitive intelligence. Now, these are specific workflows. The large corporation has their own corpus of information. They have their own workflows. So the only thing that's really going to work for them, outside of having the large backbone systems of the IP software providers, is to be able to roll their own AI solutions on their own workflow using their own corpus. And if you do this long enough, you'll recognize that the IP prompts, the prompts of the IP automation engineer, become intellectual property in and of themselves. So I'll leave you with that. So I hope that you like this, and I hope if you did, please give us a thumbs up and subscribe. If you need some expert help, just let us know. And please come join our blog at Invent Anything and listen to our series at Invent as a Work. This is John Cronin at Invent Anything.